Mr. Chairman, we are live.
Clarissa, we didn't hear you. I don't think.
It's not.
Are we live?
Mr. Chairman, can you hear me now?
We have no volume from our virtual world to our in-person world. So give us just a moment here. Master Tech Mike.
Mr. Chairman, can you hear me now?
Yep, we can.
Okay, Mr. Chairman, we are live. I apologize about that.
All right, we're really gonna have to figure out some kind of stipend for Mike as a tech guy.
Double duty.
All right, Kay, will you call the roll for the Judiciary Committee?
Yes. Representative Crago,
Here.
Representative Larson,
Okay.
Here.
Representative Oakley,
Here.
Representative Provenza,
Here.
Representative Williams, Vice Chairman Washut,
Here.
Representative Yin,
Here.
Representative Swanitzer, Chairman Olson.
Here.
Mr. Chairman, you have 9 present.
All right. We are on Senate File 19, Public Health Emergencies Immunity Amendments. We left off with, oh yes, our outfitters that were disguised as county commissioners. Or county commissioners disguised as outfitters, huh? Okay. Let's go ahead, Mark, let's let Mark in because Mark's hand was up the entire time yesterday and it's got to be getting tired because it's already up. So Mark, welcome.
Good morning.
There
we go.
Now we see you and we hear you. Go ahead and introduce yourself and let us know your thoughts.
Thank you, Mr. Chairman, members of the committee. Mark Larson with the Wyoming Petroleum Marketers Association and Convenience Store Association. We're the licensed fuel distributors that distribute fuel products at retail and wholesale throughout the state. We also represent the 345, the majority of 345 convenience stores in the state. Mr. Chairman, members of the committee, I want to thank Senator Nethercott for the yeoman's work that she did getting this bill in the form that it is, and Director Harris and her efforts to make sure that all bases were covered. The petroleum marketer and convenience store industry implemented best practices as soon as COVID came out. And when we started seeing the chairs on the deck shifted in terms of what our best practices were versus what CDC was coming up with on changes. A couple of examples, obviously, the committee knows well is the mask ordinance. And initially, there was no mask required. Then they said there were masks required and recommended. And then they came out with 2 masks were required and recommended. It was very hard for our members to keep up with the best practices. Even though we came up with our own industry best practices for sanitation in the forecourt, signs posted indoors that we made available to them. And we did everything we could to make sure that we were keeping our customers and our employees protected under COVID. Unfortunately, we did experience a significant number of recalcitrant, I'll say, customers in Wyoming that refused to abide by our signs and put our employees in a very difficult situation. But nonetheless, we had the plastic shields in place. We had our members protected, and we're hoping that there's not an awful lot of fallout from that. But to what Representative Yen was asking multiple questions yesterday, I want to address that because I know that all the other bases have been covered. Business owners know that over the last several years, we have been indoctrinated as business owners. When you get a lawsuit coming at you, you were urged to settle. I think that for decades, we've been seeing that come to fruition. And a good example of that is happening just before COVID started. We had a real outbreak of what we called drive-by lawsuits, where on ADA, the Americans with Disabilities Act, we would have attorneys that would drive in, they would find something that was not out of compliance with the multi-thousand-page ADA regulations. And they would send a demand letter to the businesses saying, you know, we really don't want to go to trial on this because we'll win. Let's settle. Let's start settle. We're not sure that that's not going to happen in some areas of the state that or the country that we've already seen. No, we haven't seen that in Wyoming, Representative Yen, yet, but we have a deep fear that that's going to happen. ADA is different, obviously, because that's very written and you know exactly what it is. COVID, on the other hand, my goodness, we've got so many different moving targets in COVID that are going to expose businesses. Unfortunately, small businesses, when they start seeing demand letters, they get upset. They start panicking. I don't want to go to court. I don't want to, you know, and if there's any possibility that I might be culpable, it could drag me into really putting my business at risk. So what we are suggesting is support for Senate File 19. The good faith standard was not adequate. We really appreciate going to the clear and convincing standard, primarily because the good faith standard will require that you go in and demonstrate your good faith protections. We think that the court ought to have some jurisdiction over that, whether it's a frivolous lawsuit or not, especially when we're seeing the proliferation of these drive-by lawsuits from out-of-state law firms, not in Wyoming. And that was on ADA. We haven't seen a significant number of those in COVID. But since the bill is directly related to COVID, we see absolutely no reason that we shouldn't go with the clear and convincing threshold. And with that, Mr. Chairman, I'll answer any questions and thank you for your time.
Committee questions? All right, Mark.
Thank you, committee.
Thank you. All right, anyone else in the virtual world who wishes to testify on this bill, raise your virtual hand. Tim O'Leary, you're on deck. Tim, go ahead and turn on your camera, and we can't see you until you do that.
It does take 30 seconds.
It's in Zoom limbo.
No.
All right, Tim, when you're ready, turn on your camera and we'll know you're there. Until then, I think you're stuck in. Oh, you're not in Zoom limbo. All right, welcome. Introduce yourself.
Good morning, Mr. Chairman. I'm Tim O'Leary. I'm with Blair Hotels out of Cody, Wyoming. We own 5 hotels in Wyoming plus 3 restaurants. And I'm here to testify that, fortunately, we've not had a single case of COVID transmitted within any of our properties. We followed all the Department of Health mandates as they were issued. We have followed all of our franchisor mandates and suggestions. We've even changed our procedures within our hotel. We brought in all new chemicals that are targeted towards COVID. We changed up our training of new employees in housekeeping to where rather than like 3 days of training before they're set out on their own, they receive 5 days of training. And then they're followed up. Every room is inspected by a qualified inspector after the housekeeper cleans the rooms. We've gone above and beyond. The mask mandate was lifted a week ago. We still require employees to wear masks for the protection of our guests. We feel that given our significantly reduced revenues due to the COVID pandemic, we shouldn't have to incur additional legal expenses to fight these frivolous lawsuits that might be coming at us. We run on some pretty tight margins here, And, with, like I say, with the decreased revenue, we just shouldn't have to go after these. Part of your premium, your insurance premium is factored in by frequency of claims in addition to other factors. And, if we do have one or multiple frivolous lawsuits due to COVID, that would just increase our insurance premiums as well. So, we definitely encourage you to support Senate File 19. Thank you for your time today, committee.
Committee questions for Mr. O'Leary? Representative Ian.
Mr. Chairman, thank you, Mr. O'Leary. I appreciate your testimony. Would you say that you have fulfilled a good faith standard of upholding the current health orders and the health orders over the course of the last year, Mr. Chairman?
Mr. O'Leary.
Representative, yes, not only would I say that we have fulfilled those orders, we've exceeded those orders.
So, Mr. Chairman,
Yes, Representative Ian.
do you think that you're currently immune under the current law then? Because that is the current law, Mr. Chairman.
Mr. O'Leary.
I would say that we might be immune, but my concern is the additional expense, the legal expense, the manpower it takes to fight these frivolous suits, and the potential for the increase in insurance premiums. I've been with this company for 26 years, and I am our risk manager, and we have had several frivolous lawsuits over the years. And this just gives them another avenue. And I believe that Senate File 19 will prevent that from happening.
Mr. Chairman.
Yes, Representative Ian.
Thank you, Mr. Chairman. Mr. O'Leary, so you mentioned the possibility of increased insurance premiums. Have your premiums increased because of our laws currently?
Mr. O'Leary.
Representative, no, they have not at this point. Not that I can tie back to COVID. Our premiums have increased. We had an increase in premium last year, but I can't tie it back to COVID.
Yeah, Mr. O'Leary, maybe you can help me. I'm having a hard time as I hear the word frivolous, and then I hear the word lawsuit, and it seems like all lawsuits we don't like are frivolous lawsuits. And it seems like, I guess I'm just trying to understand if there are no lawsuits that have been filed, if you're doing everything you're supposed to be doing, and there's nothing right now that leads you to believe that a lawsuit's going to be filed, what are the frivolous lawsuits that you're trying to prevent that you believe are coming?
Mr. Chairman, in the professional periodicals that I have read in the last year, I have read of instances somewhere else in the country, not in Wyoming, not with our company, that there is a potential for frivolous lawsuits to come at us. Keep in mind, people are making a 1 week or a 2 week vacation plan to visit Yellowstone National Park. And they get to your hotel and they get up one morning and they're sick. And all of a sudden, they might have to self-quarantine in that room for 10 days or 14 days or whatever. Their vacation has just been destroyed. They're going to go after somebody. They're going to be mad. And
Mr. O'Leary, that sounds like help me understand that. That sounds like a contractual issue that you would have. Is that what you're talking about with the individual who, so as the owner of the establishment where they're staying, that lawsuit would be contractual against you for the stay, or you're worried that their lawsuit would be against a different party, not you?
Well, I feel that lawsuit would be against us because they might file a suit and say, hey, I got COVID while I was in your hotel, while I was eating in your restaurant. How can they prove that? They just got off a plane. How can they prove that it happened?
That's a great question, Mr. O'Leary. How can they prove it right now, even without the existing law? I think that's a very valid point. That's a very difficult thing to prove where someone got COVID. I'm wondering how our existing law wouldn't already protect you from that lawsuit. They would have to introduce a pleading that would survive either a 12B6 motion to dismiss or a summary judgment later down the road. Either one, they're going to have to prove that they have some type of nexus. So if what you just said is true, if it's difficult to prove, what is the purpose of this legislation?
Purpose of this legislation, as I understand it, is that I would not end up in court trying to defend myself because there is no basis there. And I'll admit, I'm not an attorney, I'm a CPA, and I don't understand the in and outs of, getting to trial. But my insurance agent brought this topic up to me long before it ever made it to the legislature. He told me this is something that our company needed to consider as being a problem for us going forward and increasing our premiums.
Mr. O'Leary, please, I understand that you're not a lawyer, and I don't ask those questions, as a gotcha, but I ask those questions because I think it's important for the public. And I think it's important for the members of this committee who aren't lawyers to understand that this bill doesn't prevent lawsuits from being filed. And that's your testimony. So I think it's important, that we understand what the bill actually does. It doesn't prevent lawsuits from being filed. Doesn't prevent a lawsuit that is quote unquote frivolous from being filed. Changes the standard and what the individual has to prove, but the lawsuit could still be filed, and you would still have to lawyer up, and you would still have a process where they had to prove, as you pointed out, I think you pointed out the standard of clear and convincing evidence. They'd have to prove beyond clear and convincing evidence that there was some type of a nexus between the injury that occurred and their harm. But I think it's important that everyone understand that this bill doesn't prevent lawsuits from being filed. Actually, that's my understanding of the bill. If I'm reading it wrong, if you believe this prevents lawsuits from being filed, please help me understand that.
Mr. Chairman, I do not, my understanding is you are correct. It does not prevent a lawsuit from being filed, but it minimizes my time with legal expenses by defending ourselves, because the lawsuit would basically be either not admitted or thrown out almost immediately.
Further questions for Mr. O'Leary? Thank you, Mr. O'Leary. Maybe we'll have an interim meeting in Cody, one of those beautiful hotels that you have.
Absolutely. You're more than welcome. And thank you for your time today, committee.
All right, let's bounce between our virtual world and our in-person world. In person, wishing to testify, Chris.
Good morning, Mr. Chairman, members of the committee. Chris Brown, representing Wyoming's hospitality and tourism industry on behalf of the Wyoming Lodging and Restaurant Association, Wyoming Travel Industry Coalition, and we stand in full support of the bill. In 2020, Wyoming's second largest industry was hit hard by the coronavirus pandemic. Overnight visitor volume was down 21.5%, or 2 million trips. Travel spending declined 25.3%, or $1 billion. Mr. Chairman, in a previous life, I spent more than 20 years working in the restaurant industry. And I know firsthand that restaurants especially work on an extremely thin profit margin under normal circumstances, typically about 3 to 5%. I also know that businesses in our industry have every incentive to protect the health and well-being of both their staff and their guests. One thing that I heard throughout the pandemic was the challenge of having to close for a day or two because somebody on the staff either got coronavirus or was in close contact with someone. And so then a large swath of the staff would have to be quarantined. And so I know of numerous businesses that had to close down for a few days because of that. And so I bring that up only to illustrate that this does not alleviate responsibility for businesses. Businesses have every incentive to make sure that they're doing the right thing. Mr. Chairman, I want to speak briefly to a question that Representative Yin has had, and really that's been brought up throughout this entire discussion. And that is, has there been a flood or has there been any lawsuits, frivolous lawsuits that have come down? And no, thankfully, we're not aware of any. But when I think to the majority of small businesses that comprise our industry, it could just take one to derail them. When I think of one of my favorite restaurants up in Casper that's owned by a buddy of mine, it's a family business that they've put everything they have into for the last 10 years. It would just take one prolonged court case to potentially derail everything they've invested in. And so I'm not an attorney, Mr. Chairman. I can't speak to the true exact nuance of the process going in, but it's our understanding with this bill that it reduces the risk for business that have done the right thing to have to go to court and prove that. We by no means are standing on behalf of bad actors. Throughout this entire pandemic, our associations have said one thing to the industry, and that is follow the health orders closely. Do the right thing. And so, Mr. Chairman, we do feel that this legislation is important to advance forward, and I'm happy to stand and answer questions. Thank you.
Vice Chairman Washut.
Thank you, Mr. Chairman. Chris, I take your testimony to mean that your hope is that this legislation, if it passes, will deter folks who might otherwise file a lawsuit, that when we raise the burden of proof and those sorts of things, that's what your hope is, right? That we're going to discourage people from filing these lawsuits in the first place. Is that fair?
Mr. Chairman and Representative Washut, I'm not sure that folks are going to be aware, the general public's going to be aware that we even had this conversation. I'm not supporting this as a deterrent. I'm supporting it as a potential tool for businesses if they are challenged legally. Again, this pandemic has been unpredictable. It's very difficult to trace where somebody caught COVID. And so if someone brings a lawsuit forward against a small business, really what my hope is that the legal expense and time spent dealing with that is minimized and that it's thrown out as quickly as possible if warranted, versus businesses that have done the right thing having a prolonged legal experience causing them additional expense.
I think, yeah, Mr. Brown, that's the thing I'm trying to wrap my head around. And maybe I'm a lawyer, but I'm not a plaintiff lawyer, so I don't bring a lot of lawsuits. But I'm trying to wrap my head around it, because as a lawyer, owns a law firm, what happens is somebody comes into my law firm with a problem and they say, can you help me? And even when I look at this law, I don't think my answer would be, oh no, I can't. If you want to sue a business over COVID-19, I can't help you. There's an immunity statute. That wouldn't be my answer. My answer would be whether we have enough evidence to get over that burden of proof that Representative Washut is talking about, which is clear and convincing, which, what is really the difference between clear and convincing and a preponderance? I struggle with that a lot. It's something more, but how much more? So I get that, but I just think that every lawyer operates differently. And I don't think most, I'll say this frankly, I don't think most lawyers filter cases based on whether they think it's going to be something that's good for the public or good for the businesses around them or good for the state, right? At the end of the day, what a lawyer in the private realm has to do is figure out, first and foremost, regardless, they set aside all their personal beliefs and they have to figure out first and foremost, does this make economic sense for my business? That's the first decision the lawyer's going to make. In other words, is there something that I can get out of this for myself and for my client that pays the expense of the lawsuit? I think that's the number one question. And I'll just be frank. I think that sometimes the harder the lawsuit is, the easier that question is to answer. Doesn't necessarily mean that the lawyer gives up. I think you know this. Lawyers bill by the hour. Lawyer makes more money when a case goes to trial than a lawyer makes when they settle the case. So there's an economic incentive inherently built in, whether it's right or wrong, into what the lawyer has to do. So I'm trying to wrap my head around how, in what way we believe by upping the standard that when someone walks in that the lawyer doesn't say, you know what, I think I'm up for a good fight and here's what it costs you. Help me understand that.
Sure. Mr. Chairman, thank you. You speak to exactly the point that I'm trying to make, and that is attorneys do bill by the hour. And so if a case comes forward and says, we believe we caught COVID at X business and we believe that they're liable, if there's the opportunity for the judge to throw that out at an earlier instance versus having that drag out, it's our perspective that this is going to help save small business additional expense that they may not be able to afford. And Mr. Chairman, when we talk about clear and convincing evidence, just like we've seen throughout society, my industry has been no different throughout this pandemic. There have been some that have followed it to the T and been real nervous about it. There have been some that have said, we are not going to follow any of this. I'm guessing that clear and convincing evidence falls somewhere on that side of the spectrum of, for whatever reason, we're not following these orders at all. Again, I'm not an attorney, so I can't speak to that exactly specifically, but it's the reduction and the potential to reduce legal liability for the small businesses that I represent across the state that we're standing in favor of, Mr. Chairman.
Representative Crago.
Thank you, Mr. Chairman. Mr. Brown. So I want to go back to your last point about the clear and convincing evidence. And if a particular business is just not following the orders, that's going to shift that. That's where we're going to decide that they're not in compliance with the proposed immunity. My question really goes to the fact that I believe we're creating some different standard in this bill, and actually in the language that's in the statute now that was done back during the special session, which is typically we have negligence and we have gross negligence, willful wanton conduct, right? Like we have these three levels. And in this particular statute, the standard is who in good faith follows the instructions of a state, city, town, or county health officer, or who acts in good faith in responding to the public health emergency. And my question to you is who decides that on the first level, right? Who gets to decide that? And then second part of my question is, how do you believe that differs from standard negligence?
Mr. Chairman, Representative Crago, thank you. I would agree with you that we're trying to create a different standard because we're dealing with a worldwide pandemic that nobody alive has seen. And that's been incredibly unpredictable, difficult to trace. There isn't a clear line to say A, B, C, D, E with this. And so my understanding of the bill, Representative, is that the judge would be the one that would be determining, yes, it's clear, and yes, you have presented your case well and presented a good faith effort, and so I'm going to throw this out, or no, you didn't. There is clear and convincing evidence that you violated health orders. This person has a case. It's going to advance forward. It's avoiding the business going to court and having to prove that they did the right thing to the greatest extent possible that we're shooting for.
Representative Crago.
Mr. Chairman, thank you.
Pardon me, Mr. Chairman, I want to add one more comment.
Oh, yeah, go ahead.
By going to court, I understand clearly that this bill doesn't eliminate lawsuits from happening. I'm trying to reduce the amount of legal expense for businesses. And so, yes, if they have to go in front of the judge and lawyer up to prove their case, it's the judge tossing it early that we're shooting for. It's not having businesses that have done the right thing have to go to court and prove they did the right thing and to endure that expense. That's the point I'm trying to get to, Mr. Chairman and Representative. Thank you.
Representative Kriegel.
Thank you, Mr. Chairman. Follow up. So back to my negligence question, because I'm afraid, like, I'm all in favor of figuring out some sort of protection for the businesses. I truly am. But what I'm afraid of is we're creating a standard that's higher than negligence. We're creating a standard that didn't exist before. And we're subjecting our businesses to a higher standard than we would have normally. And for example, every county in the state has different standards, right? My county was very different during the pandemic than this county right here, I will promise you. And so what was acceptable behavior in our county may not be acceptable behavior in this county.
Mhm.
And so I don't get to use, for instance, if I'm defending one of these cases for a local business, I don't get to say, we acted as a normal person in Johnson County. I don't get to use my straight old negligence standard to defend my business, whomever I might be representing. Instead, I have to use the language in the bill we passed during the special session, and that scares me because I think it creates a higher level of care or standard of care, I should say, that I would not have had to defend previously.
Mr. Brown.
Thank you, Mr. Chairman. Again, Representative Crago, I agree with you. We are creating a higher standard because we're under a state of emergency due to a worldwide pandemic. That's why. And so, again, I'm not an attorney, so I can't speak to the specific nuance of differences between counties, but I've made my point, Mr. Chairman, of what we're seeking with this bill.
Mr. Brown, I want to ask you a different train of questions, because I think this probably has the potential to most apply to your industry that you represent, the signage.
Mhm.
Okay, so I can kind of understand if I have one hospital in the community and I have a sign outside, but what is my community going to look like? Is it every single business in my community is going to have one of these big signs hanging outside of their business? Or, I mean, what is that going to look like?
Thank you, Mr.
And
Chairman.
how does your association feel about that?
Sure. Thank you, Mr. Chairman. I don't think it's a big deal, to be honest with you. We've had to have signs up through this whole past year. I mean, it's not ideal, but it's a small nuance in the bill from my perspective, Mr. Chairman.
And I mean, this may be a little more legal as well. And I know Senator Nethercott kind of touched on this on assumption of risk. And one of my worries about the sign is the necessity of it and whether you truly assume the risk as is when you walk out into the world, given this, what we've never faced before, as you put it, this global pandemic is so much different. You know, when I walk into a baseball game and I get a ticket, to me, it makes sense that I assume a risk that if there's a ball that flies over, there's a good chance it hits me. But we now put those on tickets and make it really clear, but then not. But so I just wonder about the businesses who don't put up the sign and whether if there isn't a true assumption of the risk when someone goes out into the community and they choose not to have the sign, just like lots of businesses have chosen not to have the signage that already exists right now. Does that put them at a place where they can't avail themselves of this limitation on liability?
Thank you, Mr. Chairman. Again, number one, the examples you use on assumption of risk are under normal circumstances. We've been going to baseball games, whoever likes it, for their whole life, and no one has dealt with COVID for more than 1 year or a statewide health emergency to this level. Number two, I'm not wed to the sign, to the signage provision in the bill. I mean, if the committee feels and the lawyers on the committee feel that the signage is absolutely critical, I think it's something we can live within because we have for the past year. I think it's a small potatoes component of the bill. But I would leave that to your discretion, Mr. Chairman.
All right, further questions for Mr. Brown? All right.
Thank you very much.
Thank you. All right. Who else wishes to testify on this little Senate file? Yes.
Thank you, Mr. Chairman and members of the committee. My name is Tammy Johnson, and I'm with Wyoming State AFL-CIO. We represent about 17,000 union workers in the state, and then kind of a lone voice in the wind for other workers. And so I wanted to ask you about the provisions in this bill and how they apply to employees and workers. I don't know if it's the assumption of risk to assign that to an employee who doesn't really have a choice as to whether or not to go into a store where they work. Grocery store workers in particular are on the front lines and essential workers and have been throughout the pandemic. And so to say that they are assuming the risk and that their employer has no liability is difficult for workers to assume. Also, given that workers in jobs that are grocery store workers, those kind of jobs, they don't have the resources to pursue a lawsuit if they needed to. Now, we do have in the special session, this legislature passed, the old legislature, I guess, passed the File 102, which covered the workers' comp aspect and provided a presumption for workers who are at work, but that has since expired. And so part of my hope for the special session is that we can look at that statute again and bring that back. But that only applies to workers who are in the state workers' comp system. And most of the grocery stores in the state and many of the retailers are not in the state workers' comp system. So people who are on the front line don't have that protection now, nor will they unless the statute's rewritten to cover them. As far as the wanton, willful, and the negligence standard, this bill puts the burden, and I assume it probably does under current statute too, on the employee to prove that the employer was wanton and willful, and that creates a lot of complications for any worker. They're at risk of losing their job if they file a lawsuit against an employer, and if this statute protects the employer even further, then they're kind of dead in the water to start with. So I just asked the committee to consider how this impacts employees. If I were an employer and I had an employee come forward with a complaint about this, I would rely on this statute, even though I think we heard yesterday that this isn't an employment issue. I feel like this statute would protect the employer from liability. And I think that's probably part of the intent. The clear and convincing standard is tough to prove, and it would be tough for an employee to prove that. We currently have a situation in a mine here in the state, and workers are going down in the hole together all day. They're together. There's an outbreak. They don't have workers' comp coverage now, so they have to prove that they got the virus at work. It's pretty clear that they did because the way it's spreading through the crew when they're together. Doesn't mean it started there, but it means when they're working together, they're exposed to it. And now they don't have any recourse right now because they don't have the workers' comp protection, and they don't have, if they file workers' comp, they can't collect disability. So these guys are going without paychecks while they're waiting to find out what happens. So I just ask you to consider how employees figure into this bill and how they're protected. They're, like Mr. Brown said, they're there to support the business as well, and they're a very integral part of that business. But are we giving them the protections that they need and deserve as this bill moves forward? I'm happy to answer any questions that the committee may have.
Committee questions? Man, I think you raise a valid point that, and I don't know. I mean, I obviously, this is the first time I'm getting involved with the bill when it comes over to the House side, but apparently there's been, I assume, stakeholders at the table. Do you feel like the employees associations were at the table during the negotiation process while this bill was being built, or?
I'm not sure that they were. I know that I wasn't in the room when the bill was being built. I'm not trying to come in and throw artillery late in the game. I'm just asking you to consider what the ramification may be. I was heavily involved in the conversations regarding the workers' comp bill during the special session, and felt like that provision there covered a lot of people. I did struggle to try to get non-state employees covered under that bill, but that didn't happen. When you walk into the grocery store, probably 90% of the grocery stores in the state aren't in that system. So those people who are there working, they don't have a choice. They can't go home and say, well, I can, if I get sick, I'll get workers' comp. They're probably coming back to work if they get sick, because that's a class of people who can't afford to not work. They have to be at work every day. So, it's complicated because we're also including the worker comp benefit in this kind of big picture. But no, I appreciate that comment. I just was not in the front on this one. So.
Okay, because to your question, in my reading of the bill is there is no specific carve out for employee. I mean, the conversations that the business community has, now that I think about it, the conversations we've had up to this point have all been about third parties entering their businesses. And as I read the statute, unless the person seeking damages, I suppose that literally means if I'm the patron or I'm the employee, I don't have a carve out. And I would wonder, I guess I don't know if there's I suppose you could carve out employees. I just don't know what to compare that to. But I do think that's a conversation we haven't had until this point. It's a very interesting point to consider.
Mr. Chairman, I apologize that this wasn't more, I had hoped that, I struggle that workers aren't more obvious to policymakers, and not you guys specifically, but I feel like workers, we need to consider the situation that workers face in the state. And we hear a lot of testimony regularly that we've got to protect jobs and we've got to protect workers. But if there's time to put in a carve out, that would be great. I don't mean to disrupt the system. I just ask for some reflection. So thank you.
Well, thank you.
Yeah.
Questions, committee? All right.
Okay. Thank you.
Thank you for giving us more to think about. Yes. Awesome. Well, okay. Ladies first.
Good morning, Mr. Chairman, members of the committee. My name is Catherine Wilkinson. I'm here today on behalf of American Property and Casualty Insurance Association. Mr. Chairman, I apologize due to a conflicting committee. I haven't heard all of the testimony, so I hope that my comments don't overlap too much with others. But here on behalf of a lot of the insurance companies that do insure small businesses across the state, we do stand in support of Senate File 19. We would like to see our small businesses have the highest level of protection. Mr. Chairman, I would like to clarify, though, that traditionally, liability insurance does not cover pandemics. The nature of pandemics are historically uninsurable because the nature of insurance is to measure the amount of risk. And so when this first emerged, there was not, it's excluded from liability policies because you cannot underwrite for something like a pandemic. Since then, there has been an emerging market with reinsurance, which is insurance for insurance, to be sure that those claims can be paid. And it's a specialty section of that. But I did want to clear up that information. So with that, Mr. Chairman, I would stand for any questions.
Questions, committee? Representative Washington.
Thank you, Mr. Chairman. Ms. Wilkinson, we've heard some testimony about how many lawsuits. Do you have any figures of, are there lawsuits that fit into this bill that are being filed in Wyoming that you're aware of?
Mr. Chairman, I have seen a website that has been tracking COVID-related lawsuits. I think most of them are actually against insurance companies at the moment. But I will look at that source and happy to email it out to you. I haven't looked at it for a few days, so I don't have a specific number for you.
Representative Larson.
Thank you, Mr. Chairman. So you talked about insurance to cover insurance that they can get now. How would that relate if they did get that insurance? How would it relate to prior days? I mean, they probably aren't covered for stuff that happened already.
Mr. Chairman, are you speaking to the retroactivity, I assume? There's been a lot of discussion, I think, among this group over whether or not the retroactivity would apply. And I think that there's an issue with constitutionality, but however, I have become aware of Supreme Court case law in Wyoming that cases, I believe it's Chase, but I have not read it for myself, that do allow it in certain circumstances. And Mr. Chairman, I would think that it would be proper to be able to link this to the date of, the declaration of the state of emergency, which I believe was March 13th. And I do believe there is case law to overcome that. I apologize. I do not have all of that information in front of me, but I do know there are others here who have that specific citation.
Ms. Wilkinson, on so to the insurance, though, I think what Representative that is helpful, but I think what Representative Larson is wondering is, if you apply for a reinsurance policy, is it effective the moment that I sign the policy, or can I have the policy backdated to a certain point in time, such as March 2020?
Mr. Chairman, that's an excellent question. I will have to get back to you because I do not know. I have just recently learned about that, the new pool of reinsurance that has come forward to help with insuring this pandemic. So I will find out.
So, yeah, so it's interesting because you just brought a whole new conversation to it that I wasn't thinking about. The uninsured, I suppose. So, but you're saying that there are reinsurance options specific to COVID-19. We don't know, I'm sorry, but the second part of my question would be, we don't know how many, do we know what our businesses in Wyoming look like in terms of having reinsurance?
Mr. Chairman, that is correct that at first when this started, so there's reinsurance for insurance, which is basically a way to pay claims, ensure that the company is solvent and they have the insurance. So the typical policies did not initially cover this and had no resources to cover it. They would not have enough money to cover, a lot of the issues that would come up with it. So of course, a new market would emerge. And so that has been developed. So I need to get you more information on that. But I know that folks were scrambling once this did hit, and it was quickly becoming evident that typical liability insurance policies would not cover businesses for COVID-related claims, which is why we do stand in support of this bill, though, because we do want to be sure that our businesses do have the maximum coverage necessary in the event, that their insurance won't cover it. As to the Wyoming businesses with that reinsurance for the COVID liability, I need to look into that as well. I don't have an answer for you today.
Okay, that'd be helpful. But I do think at the end of the day, the point is the same, right? Whether if I'm a business, I either don't have insurance and I'm paying out of pocket for the defense costs of my lawyer to defend against this lawsuit that may be frivolous or not, or I have some type of insurance and I'm going to have some type of deductible payment. And there's a theory that because there's a claim, my premiums are going to go up. So whether you have insurance or don't have insurance, I think the message I'm receiving is some of us might have insurance that cover it. Some of us might not have insurance, but at the end of the day, there's a consequence to the business's pocketbook, whether that's in premium increases, deductibles, or out of pocket.
Mr. Chairman, yes.
Okay, yeah, we'd love to learn more about insurance. We're not the corporations committee, but
I could only wish people would say they would love to learn more about insurance, especially in the legislature. There's so few of us who would really enjoy it.
Thank you.
Any other questions? Thank you.
Thank you.
Now we'll hear from the Hospital Association.
Mr. Chairman, committee members, I'm Eric Boley. I'm president of the Wyoming Hospital Association, also leading Age Wyoming. I represent the hospitals and about 2/3 of the nursing homes in the state. And we don't normally appear before Judiciary, although I think during the interim, we're going to be working together on Title 25 issues this year, which is another fun topic for us, but we won't get into that right now. I want to recognize the good work that was done in the interim and in the special session. The immunity that was provided during that special session has been very important to all of us. But in consultation with Dr. Harris, our state health officer, we feel good protections are in place, but we also are in support of this bill because we believe that this could strengthen those protections that are afforded both hospitals, nursing homes, and healthcare workers. Some of the things to consider is this has been an ongoing and an ever evolving pandemic. We became aware of the need for protection early on as this pandemic swept the country, and early on in Wyoming, the pandemic really was kind of underplayed for a period of time. We didn't think it was going to hit us, but we started seeing lawsuits pop up around the country, and we started seeing advertisements taking place in eastern states where, just like we see sometimes when we stay at home and we're sick and watching Judge Judy or whatever, we've seen attorneys advertising, doing mass lawsuits against nursing homes and other entities across the state, across the country. There have not been any in Wyoming that we're aware of, and I'll be very clear, but there's always a concern that could happen. Changes in guidance is one of the things that concerns us. And as you guys are aware, as committee's probably aware now, the guidance has changed significantly just recently. The statewide mask mandate was lifted. CMS is starting to change, and CMS is who we answer to. That's the Centers for Medicare and Medicaid. That's the 1,000-pound gorilla that hospitals and nursing homes have to deal with. So as guidance changes, we get more and more concerned. And so early on, we were taking care of residents in our nursing homes. We had to protect them. That was where it was the most deadly. And as we look at the deaths around the country, that's where most deaths occurred, was in long-term care facilities. And we did a great job in our state protecting the residents in our long-term care facilities. But we couldn't always control those people that visited the loved ones in those nursing homes. And it became a very controversial and also explosive situation in our state. Well, now that visitation guidance has changed and we're allowed to start allowing family members in, there's huge concern. We can't control their behavior or their action. So that's why we feel like protection makes some sense. We had situations where we followed all the guidelines that we could, and we allowed compassionate care visits. We allowed a person to come in because a loved one was dying. They were told, you have to wear a mask, you have to social distance, you have to wash your hands, you have to do everything you can. And they said, we will. And then they got in the nursing home and they started hugging and kissing, and they took their masks off, and we had outbreaks of COVID in our nursing homes. Those are the kind of things we can't control, and those are the kind of things that we could be held liable for. The other thing that I think is we talk about proving where a person contracts COVID. Early on, we had the ability to do contact tracing. And so we were able to kind of figure out where people were exposed to it, but it overwhelmed the system. And so contact tracing kind of went away early on. And so it would be easy for someone to say, I contracted COVID here when it could have been elsewhere. We would have had contact tracing that could have helped us. But as some of you are aware, even our governor got treated poorly because he asked the National Guard to help with contact tracing. And it was a great utilization of their skills, but it became controversial. And so contact tracing quit. I think the thing that we would like to say, we feel like there are protections in place, but we also feel like this strengthens those protections. And we also stand in unity with our businesses, our business partners, and we would hope that they would be afforded the maximum protection too, because this is something we don't understand. And it's going to continue to change. I really worry that things are going to get worse before they get better again, even though we have immunizations that are taking place and we have some people picking it up in our country, in our state. The variances that are coming out, we don't know what that holds for us. In fall will probably be one of those times in our state history when we really figure out whether or not we really have a good handle on COVID. With that, I would just ask you to support the heroes in hospitals and nursing homes. that have protected and sacrificed, some of them the ultimate sacrifice to protect the people that they care for. And with that, I'd answer any questions. Thank you.
Vice Chairman Walsh.
Thank you, Mr. Chairman. Two questions for you today, Mr. Foley. One is the language in the bill that deals with signage and warning of entrance. If I have a car wreck and I get put in an ambulance and taken to one of your hospitals, how does that signage requirement in this bill make any sense in that situation? And I'll have a follow-up.
Mr. Bowling.
Mr. Chairman, Representative Washit, I think in emergency situations, similar to all other types of emergencies, it probably wouldn't matter too much. As far as signage is concerned, we have signage all over our hospitals that talk about, we'll take all comers, all payers, whether you have the ability to pay or not. We post things all the time. We're not wedded to the signage requirement either. But I think in an emergency situation, it would be something that wouldn't really matter.
Yeah, go ahead.
Thank you, Mr. Chairman. And then we heard testimony a little bit ago from the unions about employee. Do you have a comment about, is it different when we're trying to protect hospitals from outside litigation as opposed to litigation from your own employees if they've been exposed or something inside the workplace?
Mr. Chairman, Representative Washington, that's another great question, and it's something we've considered. I will tell you that in healthcare, there are inherent risks that are involved in the type of work that we do. It's been terrible, honestly, for our hospitals employees, and that's why we worked with the governor to bring in traveling staff, because we had such a shortage. I had hospitals at times that had 120 employees at a time that were out either with COVID or being isolated and quarantined for the 14 days. And that was a rolling average in some of our medium size, not even our larger hospitals. So we've tried to protect our employees, but it's an inherent risk, I think, in healthcare that we obviously are concerned about. We've tried to do everything we can to protect our employees. And we think there are protections in place with the original bill. And we just think this would strengthen it.
Mr. Boley, you said something, I guess, that gives us a future bite at the apple if we need it. You know, your comments about whether it's going to get worse before it truly gets better. Well, the fall will know more, I suppose. I guess I'm a lot more optimistic. I think we're over that hump. I think we're on the track to be in a much better place, and probably back to normal sooner than maybe other people think. And so I think that's why the question, and I don't think I'm alone in that belief, because the question keeps popping up, have there been lawsuits? And I think the reason why that question pops up is because we just went through the storm, what many people believe to be the height of the storm. So it's a good question. If that was the worst, then, and we don't have any lawsuits, and maybe they're yet to be discovered, which I appreciate as a lawyer too. But I suppose if we were, I think the one thing I'm trying to figure out is how we would judge the needle on the opposite side of this spectrum in terms of the cases that we prevented from going forward that weren't frivolous, that we were too stringent on. Does that make sense? Because I think it's easy to judge the needle in the reverse. We could look at how many cases were filed and how many were booted, and we could say our law did what it was supposed to do, assuming all of those were frivolous. But how many, if we go back to the scenario of people walking into attorneys' offices asking for help and thinking that they have a claim, how will we ever be able to go back and see how many cases we prevented from going forward that maybe should have gone forward, that maybe our system was too stringent? And maybe the fall would help us judge that. If there is in fact an uptick and we have more and we still have no lawsuits, I suppose we could always come back and just repeal this thing and say we wasted a bunch of time. But help me understand how we can gauge the other end of the spectrum to know that we're not keeping those employees or those third parties out of the courtroom when they don't have a frivolous lawsuit?
Mr. Chairman, that's a great question, and I don't know the answer to it. I mean, I honestly, there have not been lawsuits. No one knows what the future holds. This particular piece of legislation only pertains to the current pandemic. It does. So once the public health emergency ends, then I would imagine that this bill ends. As far as it would still pertain to, I would think, to claims or to lawsuits that have to do with COVID. But it's only for this one specific pandemic. And I think Senator Nethercott made that very clear as she drafted the legislation. This isn't for future pandemics. This is just
right
at this time. I hope, and Mr. Chairman, I hope you're right. From a healthcare perspective, we hope you're right too, that we are on the right side of things and things are trending in the right direction. We are concerned about the variants that we're starting to see. And fall is just one of those times when things really seem to tick up when it comes to illnesses like these.
Now, I certainly don't practice in the arts of medicine. But limiting this, I think you made a very good point. This is limited to COVID-19 liability. But I've also heard a lot of testimony about if we're going to have an uptick, it's probably in these variants. So at which point in time, I mean, I just don't know. When there's a variant, do we still call it COVID-19 or do we call it COVID-19.1, COVID-19.2? At what point in time after the vaccination, after the bulk, if not the overwhelming majority of our population is vaccinated and we have some other strands or variants of COVID-19, do we stop considering it COVID-19 and we lose the protection of the statute? I don't understand that from a medical perspective.
Mr. Chairman, I think that, and again, this is just my own personal opinion, and I might get roasted when I get done saying this, but I think that when the public health emergency is declared over, I think that that's a pretty good indicator. And I still think that this legislation would pertain to claims on COVID that are supposedly take place during the realm of the pandemic or the public health emergency.
Okay. I guess what I'm just trying to figure out is we already have in statute, we have an immunity. What we're doing, and I think maybe in case the public has lost track of what we're talking about, we have a statute that we are amending that deals with immunity from liability for public health emergencies. And what we're doing is we're carving out a separate section in here for COVID-19 liability. And so, what you're saying is when COVID-19 goes away, all of that portion of the statute is irrelevant. We still have the rest of our statute that deals with immunity from liability of other public health emergencies. I'm just trying to figure out if every time that's why my question about the variant is important. And I don't think it's been answered. I don't understand what happens when there's a variant of COVID-19 called COVID-19.1. And do we come back and rewrite our statute for that? I mean, so I can appreciate that we're limiting it to COVID-19, but I guess my question is that actually the right thing to do?
Well, Mr. Chairman, I can only speak from the medical side of things. And I'm going to go back to the fact that I think we have great protections in place with the special session that took place, the immunity, but we are in support of this. So influenza is a great example. It changes and it varies each year. And so the immunization for flu changes almost annually. So I actually believe that immunizations for COVID, because of the variants, we'll probably see different serums that are developed on an annual basis. But what I think is hopefully going to happen is we're going to create both herd immunity, and we're also going to create a situation where we're on top of something that we weren't on top of before. So I'm not sure it'll actually be a pandemic or whether it's going to be treated more similarly to influenza or flu, where each year we're going to be recommended that we get the new inoculation for whatever variant it is. But until we get to that point, that's where we're still dealing with COVID, and it'll have its own name, I'm sure, or it may still fall under the realm of coronavirus of some variant. But I actually am not sure we're going to be in a pandemic. We'll just be treating a new variant of that like we do flu or other annual sicknesses.
That is helpful. Representative Washington, did you have a question?
Just a comment, Mr. Chairman, on page 2, it talks about any mutation or viral fragments thereof. So I think the language in the bill anticipates some of these divergent strains.
Oh, okay. So you're looking at the definition of COVID-19 on page 2. Okay, that's where I was trying to go. I guess I didn't understand. I guess I should just read the bill. I'm sorry. Thank you, Representative Washit, but it was helpful. Thank you.
Yep. Thanks, Mr. Chairman.
Okay, anyone else? Well, I don't know that I can do hospital back to back with medical society. Let's separate it with the trial lawyers. And then we'll do medical society.
Morning, Mr. Chairman, members of the committee. My name is Beth Lance. I am speaking today in opposition to this bill on behalf of the Wyoming Trial Lawyers Association. I myself am an attorney. I've been practicing in Wyoming for 17 years. Good Representative Craig was a classmate of mine, so that dates him as well, I guess. I'm also, as you are, Mr. Chair, a small business owner. I do own a law firm here in Cheyenne. And like many of the members of the WTLA, we are primarily small business owners, as that is how most attorneys practice, as you know. We've heard throughout all the discussions of this bill and the House Immunity Bill, so many fears, right? So many businesses are just very afraid that there will be lawsuits, that these lawsuits are coming, it's going to ruin our businesses. And while I understand, of course, especially last March, right, when this was brand new, everyone was afraid. We had no idea what this was, what was coming, and what the fallout would be. But we are more than a year now past that. We're in a very different environment than we were in. And this body did pass immunity. Immunity is available right now. And by all accounts, it's working. There have been no lawsuits. There haven't been any in Wyoming. And what's on the books is clearly working. It is protecting businesses. And it also is, it has some balance to it, right? So it does also at least give, as of this point, it's not requiring things like a higher standard to be proven by someone who does have a legitimate claim, right? So there are only 2 places in the law currently in which civil law has a clear and convincing standard, and that is termination of parental rights, which you're removing a fundamental constitutional right from a parent to parent their child. So obviously that should be a very high standard. And when you are removing someone's professional license, which again, you have a property right to your professional license, and that's a constitutional right. That makes sense. That higher standard makes sense for those kinds of cases, but I haven't heard anyone explain why we need this higher standard for a personal injury case. Ultimately, that's what we're talking about here. We're talking about personal injury cases, which, obviously happen all the time, every day in this country. Personal injury cases are filed, and they're always handled under a preponderance standard. And I just haven't heard anything convincing as to why that standard should be raised for this specific personal injury. Again, I don't believe that raising that standard prevents these lawsuits. I don't think the legislation in front of you prevents lawsuits. And if lawsuits come, and if they are in fact frivolous, which again, I don't think that that's the fear that people think it is. I don't think that attorneys aren't going to file cases that don't win, right? And additionally, I think it's important to point out attorneys who bring personal injury cases typically do not work on an hourly basis. They almost always work on a contingency basis, which means someone is going to that attorney because they've been injured, because they believe they have a cause of action. And if that attorney feels that that's true, that they have a cause of action, they take that case without charging that person. And that attorney only gets paid if they win the case. So the incentive is for attorneys to only take cases that will win. Attorneys aren't going to spend all their time on these personal injury cases, which they think are losers because they're not getting paid. They're not getting paid to take losers to court. So I don't believe that that happens. I think there are safeguards against frivolous cases regardless already in our system. And then here, again, you're granting immunity, already have. So that's another closure to the gate, right? I mean, we're really closing these gates. And I think truthfully, the concern on my part, and I think from our members, is are we closing the gates to the point that someone with an actual valid claim now is being kept from bringing something? And that's where I think the balance has to be. Additionally, I think that there are, let me back up. I think there are concerns too that this now with the amendments from the original statute that we have some conflicting things here. We had a good faith standard. We've heard from several business owners, all the things that they've done and are doing where they've gone above and beyond, following the CDC guidelines, doing everything the state has asked, wearing masks, sanitizing, doing all the things they're being asked to do. And I think that's wonderful. And I think we want to incentivize that. I think we want our businesses to take it seriously and do those things. But now this bill is changing that in that we're switching now to an assumption of risk. So this is different. Now we have these conflicting pieces here. We have that we want our businesses to follow a good faith standard. And now we have, no, they just need to throw up a sign and tell everybody, you just assume the risk. If you come in here or you work here or whatever here, you're just assuming the risk and good luck to you. And that's taking away those incentives that we've at least had to encourage our businesses, I think, to do the right thing and to follow the guidelines that have been provided regarding the pandemic. Additionally, I just wanted to point out there was some talk about if there are variants, things like that, which of course no one knows. I take, Mr. Chairman, I take your position. I think we are coming out of this. I think that, obviously things have shifted. We don't have a current mask mandate in the state. People are becoming vaccinated. I do think that things are quite hopeful at this point. But I would just point out that the way this seems to be written is that it goes as long as there is a public health emergency. And so until the governor declares that there is no longer a public health emergency, this is in place. And I would be happy to answer any questions.
Representative Washut.
Thank you, Mr. Chairman. Ms. Lance, we heard several people referred to early disposition of these cases if there aren't merits. Can you describe for us non-lawyers in the room how that works, when the judge has authority to, kick a case that doesn't measure up?
Ms. Lance.
Mr. Chair, and of course, you have other attorneys who can chime in as well on your committee, but typically to start a lawsuit, you file a complaint, and that in that you state all of the grounds which you believe you have to allege your claim. If you have not made a case or you have not stated a claim upon which relief can be granted, then you may file immediately what is called a Rule 12b-6, which is essentially requesting dismissal of a claim based on a failure to state a claim that is valid.
Thank you, Mr. Chairman. And then is there anything beyond that you state the basic facts of the case, but maybe you don't meet all the requirements of the statute or something, is there a later opportunity for summary judgment or something akin to that in these civil cases?
Mr. Chair, Representative, yes, there is. There is also a different provision called summary judgment. Sometimes they actually take your 12B6 and will even convert it to a motion for summary judgment. But yes, there are other opportunities besides just at the very beginning.
Ms. Lance, I think in my rambling, I confused myself and maybe others, but I think you clarified what I was trying to say when I spoke about the lawyer making the economic choice. Because as you know, that's the number one on any case, honestly. It is honestly the number one thing that I have to decide because I'm a business owner and a lawyer. The same is true on the opposite side, which I guess is really where the on the defense side, which is really where the billable hour is. But I think to your point, the plaintiff's lawyer has to evaluate. So the 12B6 motion that we're talking about right now, the plaintiff's lawyer has to evaluate at the moment that the individual is in their office that they're going to survive a 12B6. Because why would I invest my time, my energy, my resources, my paralegal, my associate to get this file ready to go so that I can't clear 12B6 and then I don't get paid. And maybe I have some unique arrangement where I might get paid something, but at the end of the day, I think your point is that is the gatekeeping function, that we keep saying frivolous lawsuit, but those are far and few between where a lawyer who puts their skin at the game, their everything on the line to bring a lawsuit and just throw their hands up in the air and say, well, I hope I get something out of this. They're not going to do that. It wouldn't make economic sense. They're far and few between, and they get dismissed on a 12B6 motion. And the ones that survive a 12B6 motion arguably aren't frivolous.
Mr. Chair, I would agree completely with that analysis. And again, and I'm repeating myself, but I would just emphasize that I think that our system, judicial system overall, works to keep out frivolous lawsuits. You already now have past immunity, which obviously has continued to further keep out any lawsuits at all. We don't know whether we've now kept out frivolous or non-frivolous lawsuits, but we've kept out all lawsuits. And so our businesses have been protected to this point. And so I think that, anything further is just not necessary.
I think the struggle that I have, Ms. Lance, is that I'm listening to my business community. I'm absolutely listening to my business community and the desire to, I very much appreciate what one lawsuit could do to a local mom and pop shop. I mean, I appreciate what one mandate can do to my office when it has to close down. I look at my books, I know how they're affected by the pandemic, just like every other business. So I appreciate that. And I'm trying to be responsive, but I almost feel like the business community has been oversold that this bill prevents lawsuits. And I'm having a hard time understanding how this prevents lawsuits. I want the business community to have the protections that it has. Maybe what I'm also struggling with is is clear and convincing evidence versus preponderance really, is that really the gatekeeping function? I don't understand why when there's only two, as you point out, two areas in Wyoming where we use clear and convincing evidence, one where the state's potentially taking away my children. Why would we choose this standard at this point in time? I'm struggling to understand that as well. I mean, if it's one thing to state with particularity my claim, and I'm already limited on when I can bring the claim. I mean, from your perspective, what you probably still won't be okay with the bill if it says preponderance of evidence, I guess is where I'm headed.
No, I would still be in opposition, but I would say to take that out would certainly, I would look favorably on at least that being removed.
And I'm guessing, I've been asking the associations, but I'm guessing that your association does not favor retroactivity.
No, that's correct.
Okay. Further questions for the association that represents trials or trial lawyers? Yes, Representative Yin.
Thank you, Mr. Chairman. Ms. Lance, so the retroactive amendment that people have been proposing, what are the issues with it? As I think Ms. Senator Nethercott stated that it'd be more trouble than it's worth. Do you know why she said that?
I tried to get the answer out of her, but that's where we ended.
Mr. Chair, Representative Yan, there become essentially notice issues, right? So now you've been acting under a certain law, and then to create a law that then applied that you had no notice was the law, right? That becomes, I think, the issue then when you go to court and you end up with, I think, more reasons to be able to, I mean, probably what Senator Nethercott is referring to is you would have potentially more reasons to maybe be able to get rid of the lawsuit and things like that.
Good, Representative Yin. All right. Further questions for the association? Nope. All right. Thank you.
Thank you.
Sheila. Is there anybody else wishing to testify on this bill? Oh, yeah. I was going to tell Sheila to bring us home, but I won't. I'll let you bring us home.
Morning, Mr. Chairman, members of the committee, Sheila Bush with the Wyoming Medical Society. We stand in support of the bill. I did, just based on some of the questions that were asked, thought it might be helpful to give a little bit of perspective or history on how we got to this bill. Chairman Olson, as you pointed out, there is existing immunity provisions in law for healthcare providers, and those, from our perspective, really attach or apply once an event has happened and a patient is in a facility or under the care of a medical provider. In the case of COVID, which is a good example to use, there was fear among the medical community, as you all know, that they were going to run out of resources. So there's a standard of care that needs to be met in terms of caring for patients. If you don't have the right equipment, if you don't have ventilators, if you don't have the right medications, if you don't have the right personnel, it can get into a space. And the fear was we would come into a situation where physicians and facilities would not be able to meet the standard of care. I would say to you today, the existing statute covers that situation. How we landed here was the business community also felt incredibly exposed and vulnerable. And so in their conversations seeking greater protection, it was decided that the best place to put that language was inside of the existing healthcare immunity, which then created a lot of conversation about how to do that well. So the original bill talked a lot about creating a situation to contract the virus or to cause contagious situations where someone would become ill. That really isn't the concern for healthcare. So you had two very different situations that attempted to be put into one section, where in trying to piece all of that out and get to a win-win for everyone with the best of intent, you had the huge amendment that came shifting this from just sort of making minor changes to the existing healthcare immunity to almost a substitute bill, which you have with the assumption of risk. So that's a little bit of the history of how we got here. Again, we support, we stand in solidarity with the business community. We recognize and sympathize with their concerns and their fears. We do a lot of things in society out of fear, and it's hard to understand what fears are just and what fears are not. We have different opinions in this room about whether those fears are okay or justified and whether they are or not. But that is the history. That is a little bit of context. We very much appreciate the work that was done in the special session. And we do believe that the healthcare provisions do sufficiently protect healthcare. We are supporting the bill, recognizing those fears of the business community.
Questions for Ms. Bush? Very helpful. I think I'm just the one, thing I'm just struggling with is I wish I had a way, I asked this to the hospital association, but if we had a way to know what are the lawsuits that weren't filed, or even right now, I think to the Trial Lawyers Association's testimony, it at least seemed to allude to the fact that maybe there are suits out there that exist right now, but they're not being filed because the existing laws and the system that exists simply through hiring a lawyer, maybe even. But the whole system could very well be preventing cases right now. If I had a way that I could look at all the cases that I thought that I knew were going to be filed and figure out whether it worked or didn't work, it'd be something easier to adjust down the line, right? So that's the kind of balancing two worlds, right? Okay, I want to protect my business community, and but I also want to ensure access to justice. And those are the two things that we're trying to balance right now. And we would know if we had 100 lawsuits right now, we would absolutely know, okay, is there something we need to do? Example would be medical review panel, right? 2005 special session, got a flood of litigation. So we bring in this whole new system, and then we watch it for over a decade. Granted, pandemic's much more narrower, but now we know. So I'm just comparing that in my own mind that we have this ability to look at cases and know, it's not doing what it was doing. But that was a little bit different scenario because, and I guess with the Ski Safety Act, I don't know that we had a flood of lawsuits when we decided to create that act. So maybe that's comparable, but I just want some type of reassurance that we're not going to, how do we know we're not limiting access to justice too much, and we're not going too far one way, whether it's clear and convincing evidence and preponderance. Some of these things that may seem little could be the dial that's turned just enough to prevent access to justice. And I just want some reassurance.
Mr. Chairman, members of the committee, I think you make really good points. I guess my thoughts are, and part of the reason I wanted to give some of that context and history is the difference between some of this bill attaches going forward to all health emergencies, and some of it's very specific to COVID-19. And I think that was an attempt at not compromise, but really recognizing your points of, we don't want there to be too much or too heavy of a gate, if you will, for anyone accessing justice. COVID-19 was a very scary thing for a lot of people. There were a lot of questions on everyone's mind, and we knew so little about it. So, this session has been filled with, did we do the right thing? Did medicine have the answers that we wanted them to have when we needed them to have it? Everyone was doing the very best they could each day with the information that was available that day. And so this language is written to be very specific to COVID-19 because they recognized they were taking a piece of statute that's pretty broad and covers all public health emergencies and tailoring it to just addressing the concerns of the business community for this specific disease, because there were so many unknowns. And you really did have businesses doing their best, sort of weighing, do we go out of business or do we open? And if we open, how do we do it safely? And how, because of the statute of limitations, how do we prevent someone, in the future from saying, I'm positive I got COVID. We don't know what the long-term or long-lasting effects of COVID will be. There are a lot of anecdotal reports. There's some evidence, showing up about fatigue syndromes that are a result of people having COVID a year ago. So what are some of those symptoms? What will we continue to learn about this specific disease that will lead someone even a year from now from saying, had I not gotten COVID that day at that restaurant, I wouldn't have this lung condition right now. And now this lung condition is costing me, a lot in medical bills. I'm going to go and find my remedy in that one business because I'm pretty sure that night that I had dinner there, that was when I got it. And I understand that lawyers have to weigh whether or not they're going to find success and not bring frivolous lawsuits from people that don't have the evidence to support it or that don't think it's winnable. But I think we do have to, again, back to balance, weigh those concerns of business. And so But again, on behalf of the Medical Society, our concerns are a little different. I did want to really bring some clarity to why this is all kind of in the same section and why there are some carve outs for COVID and then some of them attach into the future. And if my reading is correct, we think that it successfully does that. We had initial concerns. Those have all been addressed. And with that, I would stand for questions. Not that I could really answer a lot of them.
You've been answering them so far. They're answers. Questions for the Medical Society? All right, thank you. Okay, American Heart Association.
There we go. Thank you, Mr. Chairman, members of the committee. My name is Richard Garrett, and I am a State Government Relations Director with the American Heart Association, a position I've only held since November 30th of 2020. So I didn't help build this bill, and I'm not here to unbuild it either, only to express some support for the position that many have taken on the retroactive provision that you're going to consider. We'd also like to, and I've shared with you a handout, ask for your consideration to better define that nonprofit corporations are also immune from liability in the event of a lawsuit. Speaking very quickly, first let me add, by the way, Mr. Chairman, I think that you had a question on variance. And I think if you look on page 2, line 6, Romanet II, I believe that the lines 6 through 12 address that issue that you raised. But
Thanks,
opinion.
Richard. It does. My good vice chairman kindly said, "Read the bill, stupid," to me.
Well,
if I had read that, I wouldn't.
Yeah, it's a difficult bill to read, and I'm not an attorney, so I apologize for that.
I apologize for not being able to hear.
Mr. Chairman, I truly appreciate the balance that you're trying to strike. The American Heart Association is working hard on equity, both within our organization and outside our organization. There are any number of bills that deal with equity, and I think that that's something that's at the heart of so many of the issues that you deal with. You're going to deal with one later on this morning, for example. I think in Wyoming, we do things a little bit differently. My mother spent the last 2 years of her life in an assisted living facility in Casper. About 3 months before she passed on January 19th, she was diagnosed with COVID, very mild symptoms, fortunately. It never in my, not once did it occur to me that the assisted living facility was in any way responsible for that disease being transmitted to my mother. They took wonderful care of her. And I would recommend them to anybody in this room that was in a similar situation. And I think that that is likely true across this beautiful state. It is a shame that there are those that predate on others and their misfortunes. But I guess that's a reality. So we would support this bill, and I'll stand for any questions.
Vice Chairman Washington.
Thank you, Mr. Chairman. We've heard from businesses that some of them, their insurance policies don't cover pandemic exposure risks and so forth. I assume that's true for nonprofits, but would you speak to insurance coverage for nonprofits, that whether it does or doesn't?
Richard.
Mr. Chairman, Mr. Representative Washit, I will have to get the answer to that question for you. Again, I've only been with the organization for almost 3 months, and I'm not quite familiar with it. I do know from previous experiences, specifically the organization that I used to represent did have such insurance. The American Heart Association is a very large corporate nonprofit corporation, so no doubt has that level of insurance too. But I don't know if that's prevalent within the world of nonprofits. There are many that are consists of only one or two or three people. So there's probably a spectrum, if I may assume that. Thank you very much, committee, Mr. Chairman.
And Richard, we kind of talked about this and how the statutorily, legally, a nonprofit corporation is a business entity. But you understand that, but your goal is to just drive it home and make it more clear that nonprofits are specifically spelled out in the legislation.
Yes, Mr. Chairman, that is our position. I think you might imagine it a belt and suspenders approach, just to make it abundantly clear. Yes, sir.
Okay. Appreciate that. Thank you. And congratulations on your new gig.
Thank you. Thank you very much.
All right. Anyone else in the room wishing to testify on this little Senate file? Nope. All right. How about in the virtual world?
Mr. Chairman, Mr. Cave has raised his hand again.
Okay. And unfortunately, Mr. Cave, I can't allow you to have a closing argument, or I'd have to let the trial lawyers have a closing argument too. So you did testify, and we definitely appreciate your testimony, and I'm sure your testimony would be helpful, but I only let one bite at the apple occur, especially when they're lawyers. All right. Anyone else in the virtual world wishing to testify on this bill? All right. All right. With that, I will close public comment. Committee, what is your pleasure?
I'll move the bill.
Moved by Representative Washit. Seconded by Representative Oakley. All right. Let's start with amendments. Yes, Representative Williams.
Thank you, Mr. Chairman. I have an amendment.
All right.
Page 6, line 18. After the word immunity, add the words be retroactive to March 13th, 2020.
On page 6?
Yep.
You sure?
Pretty. Page 6, line 18. This immunity shall apply.
Okay. So page 6, line 18. This immunity shall apply. Or and you're deleting apply and saying this immunity shall be retroactive to March 13th, 2020 and shall also apply to, are you looking at the written amendment?
Yes.
Because I'm trying to figure out if this is a section 2 or was there a second on the amendment? Let's do that. All right. No second on the amendment. Okay. Other amendments. Vice Chairman Washer.
I've been troubled throughout the discussion with regards to this signage and posting and putting it on tickets and claims and so forth. I think we're really late in the game to be adding in, billboards and disclaimers on access tickets and so forth. So I don't know that makes a whole lot different. I think if we're going to have litigation with regard to COVID, it's probably for exposures that have already occurred. And so my motion would be that we would strike all of the language in the bill regarding page 4, section A, line 20, 21, 22, page 5, lines 1-6 and 8-16. I think that gets rid of all the language about signs and warning labels and so forth. So that'd be my motion to delete all the signage stuff. Mr. Chairman, and it would also include subsection B, 8-16. And discussion.
Well, I mean, I think we didn't get this question into everyone, but we definitely I think as we heard testimony, I think this was the area, if we were to remove this, that our associations, our business community had the least amount of heartburn over. I think, we could, if we were to pass this amendment, we could always follow up with Senator Nethercott. But if I recall Senator Nethercott's testimony, she didn't go into depth, but she did talk about assumption of the risk and that it may not be necessary as well. Lawyers, I don't know if you have comments on assumption of the risk versus having signs that clearly state our risk versus, I mean, we all get product manuals that have more warnings on them than instructions. And I think that's really what we're talking about. Representative Washington.
Thank you, Mr. Chair. My thought was basically that had we required this in our May discussion in the special session, it may have made more sense than to put it in at this juncture after a whole year of COVID has passed to now require warning signs and labeling. People who may have been exposed, who may bring litigation, that all occurred prior to the effective date of this bill, and to change the rule, so to speak, in terms of signage and warnings at this juncture, I'm not sure it makes sense.
Okay, Representative Oakley.
Thank you, Mr. Chair. So I think interestingly enough, this then ties into our retroactivity, which I think we're still going to discuss. I think what they're trying to do here is keep it tight or narrow if you're going to get the immunity, including, really saying, look, I mean, here's signage that you assume the risk. And so I guess I don't really care, honestly, of whether we keep this in here. I do think one of the things it doesn't fit. And I think there's that interesting conflict if we were to do retroactivity. I will say in general for a lot of this, and for that reason, and I'll talk more about it later, but the fundamental fairness, I'm not for the retroactivity in general, in which case this would be fine. We can go forward or not, but this would then apply going forward, which then I think there's less heartburn on. And then as far as including it, I'm relatively ambivalent, actually, I think. Thank you.
Yeah, I mean, my position is I think it's I don't think it actually does anything, because I think that if we heighten our entire if we heighten everything when we're in a pandemic to this, everyone, I mean, we've already kind of created that mentality in our society that when you step out your door, you know exactly what you're stepping into. And I just think that the assumption of risk is inherent when you step out of the door or when you go into a crowded area. And so honestly, I don't have heartburn either way. I think if you leave it in, I don't know that you have an issue, because if you, with or without it, I think that when the person steps into the world during a pandemic, there's an inherent risk already. And they're already assuming risk. Just like I think I assume the risk, but I didn't reference the baseball game for COVID-19 purposes. I referenced it for basic liability purposes. If I sit at a baseball game, there's a chance there's a fly ball or even a home run that's going to hit me in the head. I assume that risk. It's very obvious. If I don't know anything about baseball, maybe I don't, but if I know that there's at least a chance the ball comes over and hits me, then I assume a risk. And so I don't get to sue the baseball association when that happens, or the club. So to me, that's the same thing, whether I have the sign or not. I just think it's already inherent. So I guess I'm ambivalent too. I would delete it, and I would feel very comfortable that our assumption of risk law and jurisprudence would apply. If we leave it in, I think it just means that sign companies make a little bit more money. Although if we're going to leave it in, I just think we ought to put the bucking horse and rider on the signs. And I'm pretty sure we did that in the Ski Safety Act. So just saying.
Question.
All right. Question being called on the amendment. All those in favor of the amendment signify by raising your hand. 1, 2, 3, 4. All those opposed. 1, 2, 3. Okay. Amendment carries.
Mr. Chairman,
Yes.
can I make an amendment? Because I think we actually need to do a little bit of cleanup based on that last amendment. On line 14, after the word risk, put a period, strike the rest of the line, and strike the rest of the
What?
page.
Hold on.
On page 4,
Page
sorry.
4.
On page 4,
Okay.
line 14. After the word risk, put a period, strike the rest of the line, so the win colon, and then strike the rest of the page. Because this subsection little b is actually referenced by subsection C. And so we want to, even though I don't necessarily agree with the bill, but I think we need that cleanup there to make sure that you still have the rebuttal presumption that the claimant accepted and assumed with risk.
Seconded by Representative Craigo.
Yes, Mr. Chairman, and if I may make a friendly amendment, because I was thinking the exact same thing.
Okay.
Or
yeah, depending on your friendly, I mean, I would assume that this amendment is highly, I don't think we have to vote on this amendment. It's what was intended in the amendment.
Okay. Thank you, Mr. Chairman. All I was going to add was that if we're going to put the period after risk, I think actually we should maybe add a clause behind it instead of putting a period, because I agree we need to clean it up. What I was going to propose is the language would say accepted and assume the risk of contracting COVID-19 upon, or you could say when entering the premises of another person or entity. So it clarifies when the assumption of risk actually applies, rather than just in general.
Mr. Chairman, I do think that's significant enough where we should just move it as an amendment.
Yep. So moved by Representative Craigo, or seconded by Representative Yin, or moved by Representative Yin and seconded by Representative Craigo. Sorry, Kay.
Repeat that.
Mr. Chairman, Representative Washit. So after the word risk on line 14, you would insert the language, assume the risk of contracting COVID-19 when entering the premises of another person or entity. Period.
Mr. Chairman. And Representative Craigo, where were you ending that
I
sentence?
think the way I would, so the way I'm seeing this is after risk, what you actually do is insert after risk on line 14 of contracting COVID-19. Then you can strike upon, make this all one paragraph, strike the Romanette, replace upon with when, right? So now it reads, this is all one sentence now, beginning on line 14, page 4, accepted and assumed the risk of contracting COVID-19 when entering the premise of another person or entity, and then you strike and when one of the following circumstances existed. That's it. That's just it. Okay. Okay, did that? All we're doing is combining those basically two sentences and striking the language after entity.
Okay.
All right. I think that is a good clarification. Question on the, yeah, let's vote on it. Question on the amendment. All those in favor of the amendment signify by raising your hands. All those opposed, that amendment carries. Yes, you can try again.
Give it a second shot. Thank you, Mr. Chairman. So page 7. Line 22, 23, replace line 7, line 22 and 23 with any COVID-19 liability claim as defined. With the statute there alleging acts or omissions occurring on or after March 13th, 2020.
So that's
the retroactive piece.
Yep. So now we're looking at the written amendment, the proposed amendment from yesterday, if anyone needs it, not the one from today, but the one from yesterday. I think the one from today had the wrong page and line, which is where the confusion occurred. Everyone have the amendment? Is there a second on that amendment? And tough crowd. I'm sorry, Representative Williams. Okay. Any other amendments on this bill? No. Yep, Representative Washut.
Just a comment before we vote, Mr. Chairman. I saw the big issue here that's different about lots of other liability issues is the fact that many folks don't have insurance coverage because it is a pandemic. The pandemics are excluded from coverage. And so our immunity actions in May were designed to try and make it possible for our small businesses to reopen. They'd all been closed down and they needed that reassurance that they could open their doors and invite guests to the guest ranch without exposing themselves to all sorts of liability for which their insurance company didn't provide coverage. And so I think it is justifiable for us to pass some immunity legislation. I am sure the bill will continue to be worked as it proceeds, but I'm going to be an aye vote today.
Yeah, Representative Washut, I'll be brief since it's 10 o'clock, but I'm going to vote aye on the bill. I don't know if it's there yet because I listened to the stakeholders and they're not all on board. Of course, I have more business folks in the room than otherwise, but I agree that we have to have something. I am equally afraid of the risk that a local mom and pop shop or even a large business faces. I made it clear I run a law office, so I see the bills that go in and out for some of my clients, and I appreciate what that means to them. And I know what that could do to a business. So I do appreciate the fact that we want to limit frivolous lawsuits. I have a hard time understanding what that means. I am equally concerned about access to justice. And I think that's the balancing act we are attempting to strike, is how do we make sure that an employee or a third party or whoever it is not cut off unfairly and has access to justice, has a path forward. And in the most egregious cases, I think this law will allow those to go forward. It's not immunity. It's a limitation on liability is what it is. And the most egregious cases are going to go forward. And they're going to have their day in court. And those people will have access to justice. The thing I struggle with is whether we've turned the dial too far and that there's no way, I don't see a way for us to even know or understand the cases that should have had a day in court but didn't have their day in court. And there's a whole nother conversation we didn't have today about access to justice, which is not everybody has the ability to walk into a law firm and hire a law firm. Even if it is a contingency case, it's not a reality for everyone. They still have to bear costs of that litigation. And they do. It's not all on the law firm. That's the fee. But all the costs of litigation still come out of the individual. So, there's a lot of people that that I worry that could not have access to justice if we turn the dial too far. That's the thing I struggle with, is trying to balance that. Personally, I think Representative Washut, you're right. This bill is going to get worked a little more because I don't think it's there. I don't think it's in the right spot. I think I still have heartburn over preponderance of the evidence versus clear and convincing, whether that turns the dial too far. And, we'll have those conversations as the bill progresses, but maybe we'll at least have something. And at the end of the day, I hope in my understanding of COVID-19 and the pandemic that my hopefulness is right, and where the worst is all behind us. The best is yet to come for Wyoming, and we will continue to not see any lawsuits. And we'll have spent a lot of time on this bill, and no harm will be done. Representative Craigo.
Thank you, Mr. Chairman. I too am going to vote the bill out of committee today, but I'm not sure I will be voting for it on the floor, not because I don't want to protect businesses, but because I'm afraid the bill doesn't actually do that. I don't think it does what everybody believes it does, in my opinion. I think we changed the standard of care. I think it will help some businesses in certain locations, and I think it will hurt, actually, businesses in other locations by changing what the standard of care in the legal world actually is, from pure negligence to creating using language regarding good faith. And that's not language we typically see in our line of work when we start litigating cases. And so that's sort of my fear, is that it doesn't do it. It's not going to do what we think it's going to do. And I'm gonna continue to work on it, see if I can come up with something to alleviate my concerns. So I want to vote it out because I don't want the idea to die here today, but I really think it probably needs some work before we get to third reading on the floor. Thank you, Mr. Chairman.
Sorry.
Thank you, Mr. Chairman. So, normally I get a lot of heartburn arguing whether or not a bill is necessary when it came out of joint judiciary. And not only did it get worked in joint judiciary, it got worked in joint travel, which I was on. And ultimately, this bill isn't what came out of either committee, right? It's a committee of the whole amendment that basically replaced the entire bill. So, and it really comes to the question of what's the problem we're trying to solve? And it really feels like the problem we're trying to solve is that there is a fear of lawsuits, not necessarily that there are lawsuits. And if we're just legislating to the fear of lawsuits while still in that legislation, possibly making it harder for someone to bring forward a meritorious lawsuit, then I'm conflicted. So that's I think where we need to be careful. If we're just legislating to fear and harming other people in the process by legislating to that fear, then I don't think that we've necessarily done a great job. So yes, I think we could do work to help fix it. But again, we're past the storm. I think we are definitely past the storm. And given that we're not making it retroactive, I'm not entirely sure what actual good this bill could do. And again, so the type of person that would come forward is probably one that doesn't have insurance. So, right, so they don't have health insurance, and their health insurance costs pile up because they have long-term COVID after effects possibly, to the point where they could lose house and home, and they discover that they do have the ability to track it down because we're past the storm. So maybe we have more resources to contact trace. And then they don't necessarily have enough to pass this new gatekeeping that we've put in front of them. And that's ultimately what my worry. And so I think I do have to vote against the bill. Thank you, Mr. Chairman.
Mr. Chairman, thank you. I'll be against the bill. I agree with Representative Yin. I think we're past the storm. I don't see, you don't see lawsuits now. I don't know if we're going to see them in the future. So I'll be against it.
Thank you, Mr. Chairman. I have concerns about the access to justice, but I also want to say that we heard from businesses that they're concerned that not only are they afraid of lawsuits, they also are afraid they don't have protection, that their insurance company isn't going to help them out in these issues. And maybe instead of putting the onus on, making it onerous for individuals to access justice in these cases, maybe we need to have more conversations about what insurance companies are doing to help these small businesses, instead of just trying to stick it to the little guy. So I'm no on this bill.
Thank you, Mr. Chairman. As a small business owner, I appreciate this bill. I don't think we're past the storm. I think that small businesses are still recovering financially, and families are still recovering. Our businesses in my community have suffered enough through the loss of sales and services, and I appreciate that the standards that are used in this bill are not new. I'll be an aye vote.
Okay, will you please call the roll on Senate File 19, Public Health Emergencies Immunity Amendments?
Representative Craigo,
Aye.
Representative Larson,
No.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Williams,
Aye.
Vice Chairman Washut,
Aye.
Representative Yin.
No.
Mr. Chairman, Representative Swanitzer voted aye. And Chairman Olson.
Aye.
Mr. Chairman, you have 6 ayes and 3 noes.
All right. We'll get a notice out on our other 2 bills. I saw Senator Landon, he realized that this one was going to keep going. So Senate File 49 and Senate File 75, today's Wednesday, will be carried over to Thursday at noon.
Okay, thank you very
I'll
much.
get you that email. Okay.
Okay,
All right.
thank you.